Good morning and welcome to today's Ask a Pro webinar. Today's topic, recovering with Replevins. My name is Chris Kimes, Director of Business Development and Marketing for the firm, and I will be the moderator for today. 2021 marks our second year of our Ask a Pro webinar series covering a variety of topics. Visit us at weltman.com to access our video library and other informative content. I might also suggest follow us on LinkedIn to see all of our blogs and announcements. We have an action-packed hour scheduled for you today. And before we get started, I would like to take a moment to go over some housekeeping items. I want to remind you that today's session is it's an interactive session, so please submit your questions through the question button in the control panel. Those questions will be visible to me, and I will do my best to weave them into the conversation today. I also want to thank everyone that submitted questions during the registration process. Those questions will be addressed throughout the presentation. Today's webinar is being recorded, and at the conclusion of the session, a link of the recording and a copy of the slides will be sent to all attendees. Now, let's meet the pros. I'm excited today to be joined by Amy Clum Holbrook, a shareholder out of our Cleveland office, and Al Reis, a shareholder out of our Columbus office. Amy and Al have a combined experience of over 60 years and both practice in our collateral recovery and Replevins group. We have an abundance of questions, as I stated earlier, to discuss today. So without further ado, we're going to move on to our first question, which is the obvious one. And Al, we're going to start with you. What is a Replevin?
Well, thanks, Chris, and welcome everybody. Most of you, if not all, are familiar with the use of legal actions in the collection of debts on behalf of your companies or clients. In the typical lawsuit that gets filed, the request that you're making to the court is to grant you a judgment for money, the money that you're trying to recover from your customer or former customer. In a Replevin case, a Replevin is simply a different kind of a lawsuit. In a Replevin, or whatever the Replevin is called in your state, it may go by different names. In one of those cases, you are asking the court to return or give possession of some kind of personal property to you instead of money, or in addition to money that's owed to you by your customer or former customer. So the Replevin cases that we file typically will ask for either possession immediately or possession once a judgment for possession is granted by a court. The initial issue, or the next question that we have for you, concerns the posting of a bond, and the question is, what is a bond and why is it required? And Amy's going to pick up on that question.
Good morning, everyone. Thank you for coming today. So this question of what is a bond and why do we post one is one Al and I hear all the time, as well as the other parts of our Replevin team. When I explain it to clients, I try to explain it in this way. We value some things as fundamental: life, liberty, and property. The notion of a Replevin or a debt new or a claim in delivery is that we are removing someone's property right. And when we do that, we owe some insurance to that person that we are not there for a bad purpose. Remember, we're using a mechanism inside each of these states to regain collateral or regain property that our clients claim an interest in. So the bond, what is a bond? It is the insurance to our other side that when we take possession of this property, we're not doing it with malintent. We're going to pursue our case. Now, when you're a financial institution, you wonder why do we have to post a bond? Remember, we work within the confines of the law that exists. And one of the things we're doing with the Replevin action is going in sometimes before final judgment and taking someone's property right. The bond acts as the insurance to the person whose property we've taken that we're acting in good faith. We post it because the law requires it in almost all our states. And we do it so that in case something were to go wrong in a case and a piece of equipment or a piece of collateral was destroyed, there's something to make the person whole whose property we've removed.
Thank you, Amy. Al, maybe you could help us. What is the dollar amount of a bond, or what does a bond cost?
So typically, and remember, as we go through this conversation today, as Amy alluded to, the Replevins have different names across the country, and different procedures are dictated by each state. So keep in mind that we are attempting in this short session to kind of generalize the procedures and the cost of the various actions that we're talking about taking. In general, the dollar amount of the bond is equal to twice the value of the item that you're trying to recover. So if it's a motor vehicle, it's twice the value of that motor vehicle. If it's equipment, again, twice the value of that equipment. The cost of the bond currently is running about $9 per thousand. So if I can use as an example the typical motor vehicle, if the NADA or Black Book value of that vehicle is $20,000, then the cost of the amount of the bond that would have to be posted in order to get immediate possession of that vehicle would be $40,000. And at $9 per thousand, the cost of your bond would be $360. And typically that's a bond, that's a premium, so to speak, that you pay, and that would last at least 1 year.
Thank you for that explanation, Al. Amy, where do you obtain a bond?
So there are surety companies out there that will acquire bonds for you. We at the firm can also acquire a bond if you're a client of ours, if you don't have a standing bonding company. There are different ones out there. Be prepared when you go to apply for a bond, especially if you're not a standing company within their portfolio of work. They may ask you a lot of questions. Not so much if you're a public company where we can gather the data and we can tell them that you're a legitimate company. So, but when it's a private company, whenever they don't know you, they may ask for a lot of questions, because remember, this is an insurance payment, and should that bond ever be called upon, they're going to pay it out. And so that is why sometimes when you ask me to get you one, I'll come back with an application that you'll have to fill out for me. The common ones are Brunswick Company, Highland. I've seen Chubb do them. A lot of people have their own bonding companies because of the nature of the business they're already in. I guess the other thing I want to throw in about bonds while we're talking about them is that we often talk about our clients posting them, but I'm sure Al and I have both had the same experience where we might have our defendants, our consumers file a bond. They can also sometimes file a bond in a Replevin action to keep possession while litigation is pending. So there's a lot of things going on with this bond. It always raises lots of questions. So I hope that helped. But there are surety companies, they ask for information, there's an application process, or you can have your attorney acquire one for you.
Got it. And it sounds like we can kind of coach people through that process. So thank you for that. Hey, Al, we get this one all the time. When is the bond released?
Well, the bond is released when it's no longer needed. So as Amy mentioned, the bond is posted in order to protect the other party against errors that you may have made in the process. And at the point when there is a final judgment entered in your favor or against you, that is the event that eliminates any question about the propriety of your action and whether or not it's going to be questioned or reversed. So the final stop point is when a judgment for possession of your property is granted or a judgment is entered against you, giving the property to the other side. At that point, the bond can be released. Typically, as I mentioned, the bond premium covers you for a year. And so one question that comes up is whether or not there needs to be a formal cancellation or release of the bond, which, yes, can take place as soon as the judgment's entered. If necessary, we can contact the insurance company or surety company and ask that the bond be canceled. Or many times we'll simply allow the year to expire without paying the next year's premium, and then the bond is automatically canceled at that point.
Great. Well, you just answered a question that came in while you were speaking. So thanks, Al, for being a step ahead. I like that. Moving on from bonds, Amy, what if I don't know where the collateral is located? What do we do then?
Well, the perfect case is when we know exactly where our consumer or our defendant is located, and we know exactly where our collateral is located. We care about that because, remember, the nature of a Replevin action is that we are trying to use law enforcement oftentimes to go get collateral you couldn't otherwise obtain. You've had a breach of the peace, something has happened, it's locked in somewhere. So why that's ideal is that we really do want to know. It gets a little more complicated when we're not sure where it is, because remember, I'm sending law enforcement out there. They're looking for the trailer, the motorcycle, the car, whatever it is, they're looking for it, and I'm sending them out there and we don't know. Now, there are times and occasions when we will pursue a case and we will sue it when we don't exactly know where it is, but we think that the defendant might disclose where it is. That's often recreational equipment. Where do you dock the boat? Because we're going to serve them. Hopefully we know where the defendant is. We're going to get good service. And then we're going to have that defendant disclose where it is. That might delay your case, though, because as we'll talk later down the road, what do you do when your collateral is not in the county where you brought your action? So it's not ideal. We need to have a really good discussion about what we do know, what's the nature of our collateral, what's it worth, what's it used for, when was the last time we saw it, because that's kind of a case-by-case analysis of making sure that, you know, we're not wasting the court's time, your time, the expense of doing this when we're not entirely certain where it is, but those can be productive. We can have a defendant who is under contract to be in the care and custody of your collateral or your equipment and have them divulge where it is. And remember, Replevin also has value sometimes to a degree that when people are served, sometimes they surrender. Even if they're not, even if we're not sure where it is, they say, look, the boat is docked here, go get it. So there is value, but again, it's really an analysis one by one of the case to make sure that it's a good move, and always, ideally, we want to know where it is.
Right. Well said. Al, what if a third party is in possession of the collateral, such as a repair shop, law enforcement, or another family member? What do you do then?
Well, this is a topic or a question, Chris, that we could probably spend the rest of the hour talking about, because this is really the gist of what issues come up in the course of a Replevin case. So I tried to distill this down as much as I could for purposes of our conversation. And if you're sitting at your desk and you have a pen or pencil, if you want to make a little chart, across the top of your chart are 3 boxes, and that would be one for repair shops, second one for law enforcement agencies, and third is for third parties. And down the left side, there are 2 different options. One is general personal property, and the second one are motor vehicles. And I'll go through each so to give you an idea of why I put this in kind of chart form. First of all, as to third parties. So if a family member has your personal property, if you lent the car to a friend who won't give it back to you, that's the third party. So a third party who has no claim, ownership claim, or claim for repairs or lien of any kind, simply is in possession of the item that you want back, that is a prime reason for a successful Replevin. That individual has no claim, and therefore you have a right to obtain a court order to recover that property from that third party. You have to name that third party in your case along with the owner. I'm sorry, you have to name the third party in that case. You have to serve that party just like they were an owner. But once you get them served and you get an order, then you have no doubt about your ability to recover that collateral. The second one that I want to talk about is what I've asked you to mark as repair shops. So what if the item that you want back, that you have a lien on, you're the creditor, you have a lien on a piece of equipment or a lawn tractor or a toolbox or any other personal property. Remember, a replevin can be used for any kind of personal property, but not real estate. So if it's not real estate, it can be recovered through a replevin. So if that piece of equipment is in a repair shop and you are the creditor that has a lien on that equipment, can you get it back? The issue or the answer as it pertains to general personal property is probably not. The repair shop is going to have what's called a bailment lien for the work that they did on that piece of equipment that is not a motor vehicle. And the repair shop is probably going to have to get paid before you can assert your lien and get that piece of equipment back. And that would be an appropriate result under the Uniform Commercial Code. The other question is, what if the property is in a repair shop, but the item that you want back is a motor vehicle? Here, the question becomes one of state law, because in about half of the states, the answer is the same as with any other kind of personal property, and that is that the bailee, the repair shop that has the vehicle and has done work on the vehicle, is going to have to get paid before you can take the vehicle back based on your lien on that vehicle. In the other half of the states, approximately, including Ohio, which is sort of the base that we're working from, that have specific statutes involving motor vehicles and liens on motor vehicles. There is a specific statute in Ohio, and this has been upheld all the way up to the Ohio Supreme Court, which indicates that the lien holder, the party that has the lien on the title to that vehicle, is first in line to get possession, no matter who has it, no matter what work has been done on it, and no matter what kind of a lien for repairs that repair shop or storage facility might have. So if you're in Ohio and you're the lien holder, you win. You get the car before anybody else does. If you're in many other states, you would have to pay that lien to the repair shop before you get the vehicle back. The third category, the third box that I told you to put on your sheet, is law enforcement agencies. And this is a huge category because there are a lot of different reasons why law enforcement might have possession of that collateral, whether it's personal property or whether it's a motor vehicle. For example, the property may have been stolen, and law enforcement is holding that property as evidence in a pending criminal case. In that case, you may have to wait until that criminal case is concluded before you can get your property back. The property may be a motor vehicle that was left abandoned down the road, and the police came along and had the vehicle towed. Well, the tow place in that situation is entitled to get paid. They have to go pick up that car whether they want to or not, and so the statute says that they have to get paid before that car can be recovered from the impound. What if the car is under a forfeiture? What if the individual was picked up for DUI, and now the prosecutor is attempting to have the vehicle forfeited to the city or county because of the DUI or multiple DUIs? In that case, you may have to actually go into court and make your interest known to the prosecutor. And again, there's a statute that's going to cover whether or not and when you're entitled to get the collateral back, and how much you might have to pay to get it back. And so you can see this is all a matter of the reason why the vehicle's been taken and what it's going to take in order to get that law enforcement agency to release the vehicle. This is a prime situation where if you speak to the prosecutor or the law enforcement agency and you don't get a quick answer or quick release of the vehicle, this is the prime time when your attorney needs to get involved and file the appropriate request to the court to get the vehicle released. It's not a replevin. You don't have to. You're not adverse to the prosecutor or the police agency, but you do have to make your interest known to the court and have a judge award the possession back to you. So I hope that wasn't too confusing, but there are a lot of issues that come up in this scenario.
No, certainly,
And
but
on
a
these
very
type
good
of cases,
exercise. Go ahead, Amy.
Go ahead,
I
Amy.
was just going to throw in that one of the things on this area too is just good documentation on your side. We're relying on the, particularly when third parties are in possession. We need you to make sure you're documenting how we know this third party's in possession. Also documenting when you speak to law enforcement or court systems or bailiffs or impound lots, who are you talking to along the way? Because remember, when we go to court, we might be relying on that data. So good record keeping on those is really important, and making sure you notify lawyers timely that you have a notice of seizure, because sometimes in some of these states, there's almost no time to make sure that we protect your interest in the vehicle.
Right, thank you. Well, here's a story problem for you, Amy. What happens if two people are listed on a loan, they get divorced, and one was ordered to pay?
So assuming that the one was ordered to pay was through the domestic relations court, that question comes up all the time, and we see it all the time, and people get into financial trouble when they're going through a divorce and they're separating. The reality check is this, though. When the loan was made, it was made between the financial institution and the two individuals, and that's the agreement. When those two individuals then decide to end their marital status, their union, and they make an agreement, or even a court orders it, that's between the two of them. They've left us out. So generally, everyone is, after a divorce, even when one party has been ordered to pay for a vehicle, they're still liable for the debt of the note they signed together, the contract, whatever it is. They may have a cause of action against each other for failing to adhere to their agreement through the divorce court, but because we're not a party to that agreement, we never agreed to allow the parties not to be liable, we don't generally have to adhere to it. So you'll often see in Replevin cases, I'm going to tell you that maybe the vehicle is titled to one party, but two parties are on the note, but we're naming everyone. We're naming everyone so that we put someone who might have an interest in the vehicle, that estranged spouse, that divorced spouse, we're putting them on notice of what we're doing, because they could assert an interest in our vehicle. We should tell them what we're going to do. But by and large, our agreement is binding on the parties who were present when that agreement was made, who signed that contract. The divorce decree is between the two of them, and they may, like I said, have their own cause of action to go after each other, but we're not a party to that.
Got it. Thank you for the questions that are coming in. There is one that I'll jump to in just a moment after we get through some that we've already kind of touched on. But Al, you touched on this earlier. What if a vehicle's in one county, but the consumer is in another?
So this question really relates to where the case should be filed, and that which is called the venue. And so in general, across the country, the proper venue in which to file any kind of an action against a consumer is either where that consumer resides, where the consumer lives, or where the contract, if there was an actual contract, where that contract was entered into. And so, so for that reason, and because of the fact that we must get service on that consumer before we can actually initiate the case or proceed with the case, for those two reasons, we should file the case where the consumer resides, where we can get service on the consumer. And a final reason to bring the case where the consumer lives is the fact that all of this personal property, no matter what it is you're trying to recover, whether it's tools or non-titled property or vehicles, they're very mobile. And so if you think you know where the vehicle is and you try to file the case in that county, well, by the time you file it and serve anybody, that motor vehicle or truck or whatever it is could be anywhere. And so you should use and serve the case file the case and serve the case where the consumer resides. Once you have an order, once you have a judgment for possession, once you can employ the sheriff to serve the order and get your property back, that order can be moved from one county to another. So if the consumer lives in Hamilton County, but the truck that you're trying to get back is in Warren County. The Hamilton County Sheriff can take your order and they can transfer it to the Warren County Sheriff for execution very, very smoothly. Then they're used to doing it.
Thank you. Amy, you're gonna like this one. Should I just pay a repair shop that has possession of the collateral?
There will be times and occasions when we will tell you that you maybe should, and there will be times and occasions when you shouldn't. Really, we're going to talk later too, I think, but about what's your collateral worth and what's happened to your collateral. Has it been wrecked? Has it been destroyed? How much work has been put into it? Al already sort of laid out for you that we sort of have a 50-50 split in our states about whether or not the repair shop has a superior interest in our collateral over the lien holder. Sometimes, look, anytime you go to court, it's going to cost you money. So sometimes we're making a really good business decision when we pay them. Maybe they've increased the value of our collateral. Maybe they put a new transmission in it. Maybe our consumer ran it into a telephone pole and this company has done the work and we're going to get some value from it. And that's a good discussion to have as to whether should we pay this person and just be done with it. I would say whenever we're starting to talk about big figures, big numbers of repairs or body work that's done, I'll always tell you I recommend you getting an inspection. If you're having cars repossessed by a repo company, most of them have inspectors who will go out and look at your collateral. What you don't want to do, right, is pay for work that was not done in a workmanlike way. Like the car's not drivable or it's not road safe. The repair work wasn't finished or it was shoddy. So if you're going to start spending a lot of money, you're really going to need to do your research and send out your agent. Inspections, in my experience, have run anywhere from about $100 to $250 to $300. But sometimes that peace of mind when you decide to pay that repair guy is okay. And remember, they can, if a repair shop or a body shop takes possession, they could not let you have it back. They have to file a Replevin. There's cost associated with that. There's time. Even though their claim might obviously be not valid, still, there's always that business decision to make about whether or not to do it. The important thing is, if you're going to pay, make sure you know what you're paying for. Watch for frequent flyers. I know in Ohio and Indiana, we had some storage companies that were popping up for people who had filed bankruptcy, and then their vehicles had turned up in a impound lot. And what we saw to the clients was that it was the same company and they had sort of this business model of storing vehicles and then asking lien holders to pay for them. Watch for trends. Most repair shops are honest places. Most of those guys are just getting by too, but you want to watch and pay attention to that stuff and make a good business choice.
And one other, if I can jump in here, also in those states that provide for the repair shop to have the superior lien, you also have to be very careful in the states that also provide the opportunity for the repair shop to actually conduct what's called a lien sale of that vehicle if they're not paid. And so some of you are familiar with the statute in Florida that is kind of running rampant in southern Florida especially, whereby the repair shop is permitted to provide you with a short notice. I believe it's 30 days at this point. It used to be 14 days, if I remember correctly, for a short notice of their intention to conduct a lien sale. And if you don't respond, if you don't assert your interest and stop that sale, that vehicle is going to be sold and your lien will be eliminated, sort of like a foreclosure. So you need to be very careful if you're in one of those states or you lend in one of those states and you get those lien sale notices, that you must act quickly. And a phone call or a conversation with the repair shop is not sufficient. You have to formally file a claim to stop the sale. Otherwise, you're in great danger of losing your lien and losing your collateral.
Thanks, Al. We're doing great on time. We do have several questions that have come in, so I'm going to open this up to either Amy or Al. But this question is from a lender on automobiles and semi-trucks. So the question is a Replevin a remedy if a borrower is behind on payments, but I'm not able to recover the vehicle via repossession?
That sounds like the perfect Replevin. Provided that your lien interest is duly noted on the title, or if it's a lease that there's nothing inferior on the title document. You've got a default in contract, and as you look at your contract, one of the provisions for default, amongst other things, is failure to make a payment. You can't recover it through your normal self-help measures, and you've exhausted that as a remedy. So it would be almost the perfect case to do a Replevin, unless there's some other fact I don't know.
Yeah, I agree wholeheartedly with Amy. There are two factors that you have to consider, as well as the fact that you have not been able to effect a self-help recovery, which means that Replevin is the next logical step. But number one, can you serve this person or these people? You have to get service of your Replevin. So do you know where they are? Number one. And number two, do you know where your collateral is? Because eventually you're going to have to send a sheriff out to go pick up this collateral, and you need to know where the collateral is. Or at least you have to have some indication that you can find out from your borrower or from some other source where the collateral is. And you mentioned the semis, and that is an especially challenging group of borrowers, because the semis, as you know, are generally on the road. And so it's difficult to serve those people, and it's difficult to track down the location many times of your collateral. But they're also very valuable pieces of collateral. And so the Replevin is the proper mechanism to use to get possession.
Great, thank you. A couple more here. So this is more targeted towards Ohio. So in instances like Ohio, that the lien holder has first right and a repair shop has possession of a motor vehicle, would that require Replevin action, or is there a simpler way to obtain possession of that collateral?
I generally tell you to start by negotiating with the repair shop and to see if there's room for any kind of practical solution. Usually I get my phone calls when those efforts have failed. The repair shop wants 10 grand on a vehicle that's worth $12,000 and isn't bending on its price, isn't bending on what it's going to do. So the mechanism is always good negotiation. If you have a superior lien interest and the party won't negotiate and they won't release your vehicle, then sometimes a Replevin is the only way to get it back. And that's, you know, I think unfortunate, that's the remedy of getting it back. Now you could always sue your consumer, because generally it's a breach to allow your collateral to be in the possession of a repair shop that you didn't go get it, and just forego your security interest. But that's not always that's often not the best remedy. So the simple one is try to negotiate. I know I've called on behalf of clients trying to negotiate, arrange for the inspection, talk about what the vehicle's worth. I think on a couple cases, we've also done negotiated sales of the vehicle. Like, we're not going to pursue the consumer for a deficiency balance because maybe the debt's discharged, and now our vehicle's at a repair shop. We've negotiated with the repair shop that, look, we'll do a percentage of the sale. We'll list this thing for sale, and then everyone will walk away. But again, that's for when collateral is maybe not worth so much, or whenever the repair bill is huge for a reason. Maybe they've done a lot of work to it that's improved its value. It's really a case-by-case basis, but oftentimes Replevin is where we end up.
Yeah, this is one of those situations, one of the few situations where you actually want attorneys involved. The repair shop or the owner of the repair shop is really going to be reluctant to simply hand over the vehicle. They've put work into it, or storage into it, or whatever expense they've got into it. They do not want to give it up. But an attorney representing that party is going to understand the priorities, and he's going to understand that, at least in Ohio and the states that are like Ohio, you as the lien holder have priority. And then that immediately generates the kind of negotiation that Amy's talking about. So again, one of the few situations in business where you actually want attorneys involved.
Al's right. Like, sometimes all they want is to get 2 lawyers on the phone.
Right, exactly. We're doing good on time. There's a few more questions I'm going to try to sneak in before we move to question number 11. But sticking to the multiple county issue, do you have to commence on a new lawsuit each time the property moves around? So this individual has heard of issues where the sheriff in one county refuses to execute unless the Replevin order was issued in their county. So we have a quick answer to that one.
I think we answered it already. The sheriff in any county by law should give effect to an order issued in a different county in the same state, or actually anywhere. So a court official that takes that position is wrong. And my reaction would be probably to go to the judge in that county where the official is refusing to act and ask the judge to order that sheriff's deputy or sheriff's department to give effect to a lawful order that was issued in a different county.
Sometimes, Sheriff.
So sticking to that.
Go ahead, Chris.
Yeah, I was just going to say, so there was another question that came in about what if the vehicle's in a different state then?
Again, like I said, you can transfer. So a lot of you are in the financial services, so you know that a lot of times we domesticate inside of other states. So we can do the similar thing with if our vehicle moves from West Virginia to Pennsylvania, we can oftentimes just domesticate our judgment and have the writ, the instructions to the sheriff to go get it, work through the new place, the new county, the new state.
Got it. I'm going to keep plowing through these. What about this one? What if the repair shop or tow facility does not allow the lien holder to inspect the vehicle, Amy?
Then simply you're going to have to talk about litigation if your collateral is worth it. You know, it's really we'll talk about like if a 2000 Toyota Corolla versus a 2019 Cadillac. And what are our best business decisions? I know sometimes for especially my smaller clients, it gets personal, and I try to keep our focus, and I know Al does too, on the business aspect of what we do. What's it going to cost? What's it really worth? But sometimes that's going to be litigation. Sometimes you're going to have to sue them in Replevin. If the collateral's worth it and they're demanding a lot of money, then we're going to talk about the fact that our lien interest is superior. We haven't seen it. We don't know if they've enriched our collateral in any way, and we should get our vehicle back. So once people start to refuse things, and we don't have a lawyer on the other side of the phone who talks logic to the repair shop owner, sometimes litigation is the only way to get everyone on the same page.
Thank you. Al, this is related to storage. So what about storage at a repair shop? Is there a limit as to what they can charge?
Very hot topic, because you'll see charges that are all over the board, and most of them appear to be totally unrealistic. But number one, the issue of storage is something that is set by state law and statute. So if there is a statute in the state in which you are operating, and for the circumstance under which that vehicle was placed in storage, then you're going to be bound by whatever that statute says. As I said before, if the vehicle was impounded or taken by a law enforcement agency, there's going to be a specific statute and probably a specific amount that you have to pay to get the vehicle out. I think what you're really talking about are the private storage facilities, or the repair shop who tries to charge you $75 a day because the car didn't get picked up after the oil was changed, and now they're trying to charge you for a huge amount. Unfortunately, Ohio and most of the states only refer to a reasonable standard, and so whatever a judge determines is reasonable for the value of the storage that's taking place is what a court would give you. Now, that doesn't do us much good, because there's nothing that we can point to short of filing an action and going to court to prove to that repair shop that no, you're not entitled to $75, but $5 a day would be reasonable. Nothing like that exists in Ohio and most of the other states. They simply use that reasonableness test, which is pretty nebulous and creates a lot of unnecessary litigation.
We will not get to all the questions that are coming. I'm just going to tell everyone that's out there sending them, but keep sending them. We'll get the answers and send them as a post follow-up. But a quick question that came in is, can Weltman help me nationwide? The answer is yes, I'll handle that one. Al, I'm going to ask you this one. Can a Replevin be used to recover digital information? The example
yeah, that is one of our that's one of our questions here, and the answer is yes. Intellectual property is still personal property and can be recovered. So software can be recovered. Obviously, there are all kinds of issues that are unique to that kind of personal property, just because of the availability of duplication efforts and the difficulty of quantifying exactly what was sold and what you're trying to get back. But source code and hardware, computer hardware, disks and things like that were part of an agreement that included a security interest or a lien, yes, those things can be recovered, and they do qualify as personal property subject to Replevin.
Thanks, Al. I'm going to stick with you. We've got about 19 minutes to go. Al, what do I do with notices of seizure related to a criminal matter? Question 11.
Well, we react to those, obviously. So the notice of seizure is not the important notice that you might get. It's the notice of potential forfeiture. That's the one that you need to react to pretty quickly. So a law enforcement agency or a prosecutor seizes a vehicle as part of a criminal case. Again, the most common one is number one. It's the most common personal property is a motor vehicle. Obviously, it's a car or truck that got seized, and it got seized because the individual was committing a criminal act, most commonly a DUI or multiple DUIs. And the next step that the law enforcement system will take is to attempt to have that vehicle forfeited to the state as a result of the criminal conduct or multiple criminal conduct or some other reason that would allow the state to take the vehicle. At that point, you have to, as a lien holder, you have to step in and you have to make your lien known to the prosecutor or the state. You have to prove that not only do you have a lien, but that you are not aware of the fact that your customer was engaging in criminal conduct. And you have to promise to the state that you're not going to return that vehicle to the customer if the vehicle is turned over to you. If you meet the test, and that's all contained in a statute in Ohio and most other states, if you can meet the test, then they generally will release the vehicle to you as a lien holder, and you will treat it like any other repossession at that point with notices and a sale.
Great, thank you. Amy, what constitutes an emergency with an emergency Replevin?
So almost all jurisdictions, all 50 states, allow for something that's either phrased as an emergency Replevin case, and they're very fact specific and they're extenuating circumstances. I tell people here, like, if all my cases are a little intense, because if you were able to recover this property easily, you would have done so. There's always been a breach of the peace. There's always been something that went wrong. But in an emergency Replevin, there's pretty specific jurisdictional requirements. And what an emergency Replevin does is it speeds up the whole process. It means that for states like Ohio and Indiana, it means that the day I file it is the day I can send the sheriff out to go get it. If I'm ready with my bond and my precipice, I can literally walk into a courthouse, meet with the judge, show him an affidavit from my client, and get a judgment for temporary possession of something. But those extraordinary circumstances are often limited to destruction of the collateral, which means we have good reason to believe that our consumer or whoever's in possession is going to do something to it, take it apart, burn it, sink it in the middle of Lake Erie, whatever it might be. Or they're going to remove it from the jurisdiction. They're going to take that boat to Canada. They're going to drive that car into Mexico. These are fact specific. So it usually means something's going to happen to your collateral. It's going to diminish in value so quickly that because of the actions of our consumer, that we've got to move now. That doesn't mean we don't have to get service. It doesn't mean that we don't have to have a hearing at some point, but it allows us to take possession on this very fast basis, ex parte in front of a judge, which means without the defendant being present, and make our case. But when we do that, it's very, like I said, very fact specific, very driven by an affidavit that your attorney will draft for you that lays out why it is. And sometimes the judge will actually ask you to provide testimony or give me more detail. And sometimes they're denied. I'm sure Al can tell you about that too. Like there've been occasions when we thought we had a great case, and the judge still says no, because again, we're taking that property right without even a hearing or service. So they're of a very high standard.
Great. We got 15-minute warning here. Al, why is service so important? Now it's a big one.
Well, it is a big one, and it's the answer is pretty simple. It's because the justice system in this country requires that before property rights are impacted, people have a right to know what is happening. They have a right to be served with notice of what you're trying to do to them. And so until you get service on your customer, borrower, you cannot proceed with the case, short of the unique examples that Amy was talking about, short of that kind of an emergency that requires immediate action because property is going to be destroyed or hidden. So you must get service by whatever means that state requires before you can proceed with the case, before you can hope to be successful with the case. Now, what is service? In every state, if you personally serve the consumer or the defendant by handing him or her a copy of what you filed, the summons, that is good service in every state. Some states, in addition to personal service, allow you to serve by mail, and typically that would be certified or registered mail that would be required to obtain service by mail. Ohio is a state that allows service by certified mail or in some cases overnight delivery. Just as an aside, during this past year, because of the COVID issues, we have been especially challenged in getting service by certified mail because the mail carriers are unable to or reluctant to have the personal contact with residents to get them to sign the green card that's required to prove that certified mail was actually delivered. So as a result, we've been hampered to a great extent in obtaining service by certified mail because of the fact that we can't get the green card signed in return. And so we've turned more and more to personal service in Ohio in order to get service of process and get these cases moving. The other point where service is critical is at the end of the case, when you have a judgment for possession or what's called an order of possession, you have to serve that order on the defendant in order to execute the order and take possession of the personal property. So you have an order of possession, the sheriff in Ohio has to go back out, serve the person again with the order, and take the property from him or her. If they can't serve that order, they're not allowed to take the property. And so service is required in a replevin in those two times, at the beginning of the case and at the end before the property can be taken.
Thank you. Amy, we're going to skip to question 15. Is show cause motion really effective?
So this is whenever you got the order of possession and the sheriff's tried to go out and he can't get your collateral, he can't get his hands on it for whatever reason. Yeah, they can be effective. I know it's frustrating for clients because you really want that collateral back and you want it back as quickly as possible. But sometimes you've got to file these motions to get, and a show cause is really an order that we're asking the court to say, not only is he not turning over our collateral, judge, but he's not listening to you. He didn't turn it over and you told him to, which has a little more teeth to it in most jurisdictions. And sometimes it's as far as we have to go. Al just talked about service. Show cause motions often have to be served personally, so that means we're going to need service again. I know it's frustrating. I know you don't like it, but the reality is that sometimes they're highly effective. Sometimes their failure to surrender the collateral results in what's called a bench warrant, which is a contempt citation on a civil case that the defendants are held. And sometimes we're just trying to get their attention, so they come back to the table and either surrender the collateral or pay for it. So they can be effective. I know by the time we get to a show cause, you've been through signing my affidavit and going through service, maybe attending a hearing, and it's frustrating. But the reality check is they do have value.
Thanks, Amy. Al, I love this one. Can I use a Replevin action to also obtain a money judgment?
Yeah, this is a great question, and the answer is maybe. I hate to give you an answer like that. So there's one of three options that you have in response to this question. In some states, again about half, like Ohio, you can file a Replevin and at the same time ask for a money judgment. So you can ask for possession and you can ask for a money judgment on the underlying contract in the same case at the same time. And in some jurisdictions, you can get a judgment for the full amount that is due on the contract. At the same time, you get an order of possession. And that'll give you a money judgment, and it'll also give you that judgment for possession that the sheriff can use to go out and get your collateral. In other jurisdictions, you can file both in one case for possession and money judgment, but the court or the individual judge might make you wait until you repossess or get possession of and sell that collateral and then establish any deficiency before he or she will grant you a judgment for that deficiency amount. In the other half of the states, maybe only about 20 that I can think of, you cannot file for possession and money in the same case. You have to first file your Replevin, get an order of possession, get your collateral, sell the collateral, establish a deficiency, and then go back in and file a second action for the money portion of the case. So in those cases, in those states, you do have to file two cases as opposed to one.
Thanks, Al. Amy, this is a question that just came in, and I'm assuming it's from a credit union, if that helps. But why can't the Replevin be served to the member to force them to turn over the auto since they signed the contract, not making payments and hiding the car? Wouldn't they be forced to turn in the car within 1 day?
I know it feels unfair. And I hear you, and I hear these questions all the time. Why isn't the process faster? Remember, though, at the end of the day, the law says that even when there's a lien on a vehicle, when we've got that lien notated on the title and it's perfect, that person who bought the car is the owner. And with ownership in this country, with the fact that you own something and it is your property, government can't strip your ownership right without some form of process for us to do so. You're right, you have a security interest, you have a default, you know where he is. I know it's unfair, and but that is the protection. And if the protection is there so that not everyone who files a claim for Replevin has a good claim. It's unfortunate, but sometimes there's legitimate disputes about who has the best interest in property. So the law is there, the time frames are given, like they're given to get service, because we are stripping a property right from someone. We're taking away something that we've said that they own. I mean, Replevins are faster than foreclosure actions take a really long time too. Again, we're stripping someone's property right away from them. So we're giving some assurance that we are doing it correctly.
Thank you. I am going to get to a COVID question, but before we go to that, I'd like to ask Amy another question. If the collateral is still outstanding after judgment, can I pursue other ways of recovery, such as a wage garnishment?
So Al talked a little bit about that there are about 20 states that don't let you sue for money and possession at the same time. So when we talk about wage garnishment, we do need a monetary judgment, something reduced to an amount of money that's outstanding. So, but for the other 30 or so states, generally there's no block. So we can file, if you know where someone works, certainly I've had a vehicle outstanding and a sheriff out looking for it, and I filed the statutory notice, or I sent out the statutory notice for garnishment. There's sometimes some collection strategy to that, in that we really do want the collateral back. We think if he understands that we're serious, that he might actually surrender. As long as your state's what they call a UCC state, which most of them are, there's you can ask for more than one remedy at a time, and that's what we sort of do on these. Also, let's say that your collateral is just missing or just can't be recovered. There are oftentimes in most states something called conversion, which is civil theft. And we can oftentimes amend our complaint or add to our complaint something for conversion. Now that only gets you the value of the collateral, not the debt that's owed. So for depreciating collateral, it starts to impact how much you can get a judgment for. Also, if you can't collect on it, like the nice thing about security, right, is you get it, you sell it, you have the money. If a judgment, you still have to collect on it. So there are some other things you can do.
Thank you. I'm going to try to sneak in 3 questions in 4 minutes. So let's see if we can do this. Al, do you need a Replevin in the case of a leased vehicle?
Yes, same situation exists. The lessee has possession, you want possession back, and he or she does not want to give it to you. So the answer is yes, you would need to file a Replevin in order to get a court order to get possession back in your hands. The only difference is that instead of claiming that you are the lien holder on that vehicle and you want to assert your lien to get possession, you're asserting that you're the owner and you have the right to get your own property back. And in that case, the order that you would get is for the return of the property that's titled in your name. The procedure is the same, the length of time it takes is the same, the cost is about the same. It essentially is just difference in wording in the complaint that you file.
Thank you so much. This is from a utility client, I would imagine. From a utility standpoint, since we technically own the meter, are there any steps that we can bypass in order to begin and complete the Replevin process? Amy or Al?
I'm not sure what you mean by meter. I'm really not sure what you're talking about, but if it is a utility type meter that you're trying to recover because it's the property of the utility, the only issue besides the general issues that come up in a Replevin would be whether or not that meter has now become a fixture on the property. So if it's affixed in such a way that it can't be easily removed, it may not be part of that real estate, and so you cannot use a traditional Replevin in order to get possession. But maybe we can clarify what you're talking about.
Yeah, and I would also say watch for state and local statutes as it pertains to gas meters, particularly in the era of COVID. You know, it's an unusual time to be pressing law. It's an unusual time to be a creditor. I would be very cautious. I've heard of cases in not Ohio, but in surrounding states where those attempts have been made, and sometimes successfully, but I would be really cautious to watch state and local statutes on those.
Got it. Thank you. This is going to be the last question, and then all unanswered questions, we will get answers to everyone. But this is one that certainly has been coming up quite a bit in 2020, and I'm sure will continue in 2021, at least for a while. But in instances of service via certified mail, United States Postal Service has been delivering certified mail and writing COVID-19 or something similar on the return receipt. Is that sufficient for service? Last question.
That's entirely up to the judge.
I knew everyone would enjoy that one.
There is
Go ahead. No, you're good.
I just want to mention that there is an order that came out of the Federal District Court, Southern District of Ohio, and that federal court has specifically stated that if the green card comes back marked COVID-19, that court will consider that to indicate good service. And the analysis was that the carrier should not be marking the green card as COVID-19 unless the mail was actually delivered, but the carrier was unable to obtain a signature by the resident because of the need to maintain the 6-foot distance. That's what the federal court says, but we've already had state court judges in Ohio tell us that they are not going to follow that rule or decision, and they are requiring that there either be a signature or that we find some other way to get service. I'm sorry for talking over you, Amy.
Oh, no, you're fine. It's the same experience I've had, is that I've just now taken to calling the judges' chambers and asking them what they're going to do with it, because there's simply no predictability. And I actually had one person change their mind. They told me I didn't have service, and then we had a case management conference, and suddenly I had service. And it was that COVID-19 signature. I made some recommendations to clients on cases that are worth it to get a special process server, because service is key. You can't move forward without it. And reissuing 3 times certified and still getting that COVID-19 in a court that won't recognize it isn't getting us anywhere quickly.
Well,
I'm using personal service or process servers on every Replevin, just for the reason that Amy said, that the time is important. The time is more important than the few extra dollars that it takes to get service. So we're actually using a private process server appointed by the court so that we can check multiple addresses at the same time.
And we do the same up here in Cleveland.
We are up against our time. I just want to, Al, Amy, thank you so much information. Thank you all for all the questions. We will get you answers to those. I hope you found this session to be informative. I know I did. Remember, you will be receiving a copy of the recording as well as the slides. I do want to call your attention to our next Ask a Pro webinar, which is Navigating Chapters 7 and 13 Bankruptcy Part 2. You can get Part 1 by visiting our website. That is Thursday, February 25th. Should you have additional questions, or if you'd like to speak directly to our pros, you'll have their contact information, or you can email me direct at ckimes@weltman.com. My email's on the screen as well. Have a great rest of the day. Thank you so much, and we really appreciate the time.
Thank you, everyone.
Thank you.